for admission. Item number 1.
Lordships, on the last occasion, the state was ready to place a notification which the commission had adopted without the payment of compensation.
What is the subject matter here?
The construction of the road from Kohima to Gauhati.
Okay.
Worship, with your apology, due to some documentation, I could not file the affidavit. So I will be allowed to file in the next sitting. Regarding the acquisition and requisition of land.
Acquisition and requisition of land.
In that connection, there was a sitting between the state official and the managing director of the NHIDC.
What was the last order?
13/3/24.
13/3/2000. Two thousand 24 order. 13/27. By the previous order, 3 things were directed. Mr. Imsong was directed to
Yes. Your
file
Lordship.
an affidavit.
Yeah, Your Lordship.
Secondly, a status report is to be submitted by the NHIDCL. And third is the contractor. Who represents the contractor?
Your Lordship, I am representing your contractor.
Contractor.
My Lord.
Have you brought any status report on record?
Yes, my Lord.
You have filed something.
Yes, Lordship, it was filed this morning. I hope the file has already reached your Lordships.
Okay. Anything has come? Nothing has come. Yes, Mr.
This morning.
You have filed this morning.
Lord,
You have received
I
copy.
received copies. Madam.
Mr. Seki,
My Lords.
what is the status report?
Your Lordship, the progress that has been achieved so far is 62.12.
What was the time of completion?
Lordship, May,
May 2000?
this year, Lordship, May
This year.
2024.
Only 60.
62.12.
But the major part of the works that are time consuming, Lordship, those are all complete. But the earth cutting part in some areas that needed to be done are all done. The subgrade, sub-base, these are 100% complete. Then non-bituminous base course that has come to 78.45%, bituminous base course 54.56, and the final layer also 30% complete, Lordship.
So I don't think you'll be able to meet the deadline.
Lordship, as far as my conversation with my clients are concerned, it appears it is achievable. There's some minor works like the drain and all the side works, but as far as the road is concerned, there should be no problem in completion unless the weather gives a problem, Your Lordship.
Yes, you have gone through.
Yeah, I'll go to my Lord. Yes. So the contractor says 62.12 and the 63% actually.
Yes, almost 63%.
And the NHIDCL says 62.12. So 1 percentile difference. That's all.
Okay. So what should be done today? Because status report is not available with us. from the contractor as well as from the NHIDC.
Status report, your lordship, it's just the percentage of work done. That's all. So contractor says 63%, and NHIDCL says 62.12%.
And what is the outcome of the meeting?
That has not been placed on record. That is why the DAG is asking for some time.
Mhm. Yes, Mr. Imsong, when can it be done?
By next week, by next sitting,
By next
Your Lordship.
week? By next week?
By next week. Next.
Next DB? Next DB will be on 3rd of April. Possible or 10th of April?
10th, Lordship, 3rd, I will be out of station, my lord.
10th.
By 10, Your Lordship.
Yes, Mr.
That's fine, that's fine.
No, status report is not there.
It will be coming very short. They filed it only this morning.
Heart, Mr. A. Jimomi. Learned amicus curiae. Also heard Mr. Imti Imchong, learned additional advocate general for the respond number 3, 4, 5, 6, 7, 11, and 12. Mr. Mohajami, learned standing counsel, NHIDCL, and Mr. J. Seki, learned counsel for the contractor,
Lordship, I am appearing for respondent 10, the authority engineer.
and Mr.
Cynthia,
Cynthia Anger,
for respondent 10.
learned counsel for the respond number 10. Contractor is implemented as respond number
9, my lordship.
okay 9, and NHIDCL
2 and 8.
2 and 8. Huh? In reference to the order dated 13/3/2024, Mr. Sheki, learned counsel for the contractor, and Mr. Jami, learned counsel for the respondent NHIDCL, have submitted that respective status report in reference to the order dated 13/3/2024 has been submitted on behalf of the contractor and the NHIDCL today. Mr. From the status report submitted by the respond number 9 contractor, comma, in the status report, it is reported that the physical progress for the contract work has been achieved to the extent of 63.18%, with financial progress at 61.83%. On the other hand, as per the status report submitted by the respondent NHIDCL, in the status, the APC contractor has achieved 62.12% physical progress, which 61.83% towards financial progress. The two status reports submitted by the respondent NHIDCL and the respondent number 9 contractor are taken on record. Mr. Imti Imchong, learned additional advocate general, Nagaland, has submitted that has sought for 2 weeks time to bring on record the minutes of the meeting held between the state administration and the NHIDCL authorities by way of an affidavit in deference to the order dated 13/3/2024. Post of having considered the prayer made on behalf of made by Mr. Im Chong, and Additional Advocate General on behalf of the state of Nagaland, let the case be posted on 10/4/2024 for filing of the state for filing of the affidavit by the state respondents in deference to the order dated 13/3/2018.
Motion.
For admission, item number 2.
May I please, Your Lordship?
Yes.
By order dated 28/2/2024 and 13/3/2022, respondent number 3, that is the Department of Social Welfare, was directed to file a comprehensive reply on the funds received from the ministry. Lordship, I'm appearing for respondent number 3, and I'm filing my comprehensive affidavit today.
Today,
Lordship,
during the course of the day,
Lordship.
You have received the Indian government affidavit.
Lordship, yes, I've received a copy. Lordship, where's the direction was for the state to file their comprehensive affidavit? Lordship, I would also, as directed by the court on 28 February, I would also be filing my additional affidavit. The exercise is ongoing, verification is going on from from the petitioner's side. So I will need some time to complete the exercise, Lordship.
So there was an observation also that in the event you do not file your
Lordship.
affidavit,
Lordship,
the personal presence of the Director of
Lordship.
Social Welfare should be called for.
Lordship, Lordship.
So you have not filed any affidavit
No, I'm filing my,
today.
yes, Lordship.
And Ms.
Nitya Prasad.
Koja,
Nitya Prasad.
so what time
Lordship, I'll
you
require.
require for filing your affidavit in
3
terms of?
weeks. 3
3
weeks,
weeks.
Lordship, yes, Lordship.
Okay, let us in the meantime fix it on 10th of April or 3rd of April to see what the state
Lordship.
government has explained, how the state government has explained as regards utilization of the funds.
Then Lordship, Lordship,
10th.
then Lordship.
Heard Miss Nityo Koja, Learned Counsel for the petitioner, Mr. Yangarvati, Learned Central Government Counsel for the respondent number 1, and Mr. MS
Apila Santam, Lordship.
Apila Sanctam, Learned
Engage counsel for. respondent
Engaged
number
Counsel for the respondent number 2
three.
to 4.
Three, Lordship, three.
3.
Three, Lordship.
Who represents 2? Okay, Mr. Learned Government Advocate, Senior Government Advocate, Junior Government Advocate for the respondent number 2 and 4. And MS Apila Sanctam, Learned Engaged Counsel for the respondent number 2.
Three, Lordship.
3. Those two. MS Koja, Learned Counsel for the petitioner, has submitted that records are being stroke information stroke data are being analyzed, are collected and analyzed in order to file the affidavit in deference to the order dated 28/2/2024.
Lordship.
And he has submitted that some more time would be required to file the affidavit,
Additional affidavit, Lordship.
additional affidavit. In terms of the order,
Lordship, yes.
in reference to the order dated 28/2/2020. MS Sanctam, Learned Counsel for the respondent number 3 has submitted that the affidavit in reference to the orders dated 28/2/2024 and 13/3/2024 to be filed during the course of the day. A copy of such affidavit shall be furnished to MS Koja, Learned Counsel for the petition, and also to the other respondents. Also. Please the case. Please the matter. as agreed to by the Council of Parties. Comma on 10/4/2024 for the purpose of consideration of the affidavit we filed on behalf of the aspirant number 3. For
Published lordship.
Before as the affidavit on behalf of the aspirant number 3 is as it has been submitted that the affidavit on behalf of the aspirant number 3 is going to be filed during the course of the day, comma, the observation as regards personal affairs of the Director of Social Welfare
Lordship, that's not a department.
is respected for a time being.
For admission, item number 3.
Next motion. Worship, here, what is put up regarding the setting up of the blood component separator at Naha Hospital Authority, Kohima. Now the issue is telling the who will issue the licenses,
Blood
component separator,
separate.
component separator. Now, Lordship, I just got information.
What purpose it is achieved by installation of that facility?
Lordship, here they do the separation of the blood components, Lordship, by WBC and the RBC.
RBC and WBC.
Yes. Now, I've been informed that the
It
license.
is prescribed by the rules.
Yes, Lordship. Now, the issue was going on whether as to who will be the licensing authority, Lordship. Now, I just got information that we have already got a license from the Central Licensing Authority, Department of Health Services, Ministry of Health and Family Welfare. So I would like to place on record the license, Lordship, that has been given to us. So a week may be granted, Lordship. I'll inform the council for the also.
Yes, Ramesh Pooja.
Lordship, yes, Lordship.
Yeah,
In fact, there's been a development in the case as per the order directed by the court. And affidavit placed filed by the state respondents, Lordship. Besides the blood component separator, they also mentioned that 3 blood banks in 3 districts are under construction. That is, Lordship, in
What is your substantive prayer in the PIL?
Lordship, my prayer is that to have at least 2 blood components separated in the state. One in the Eastern Naga area and one in the Naga Hospital Authority, which is already there, but due to the lack of technician, it was not functional. But during the course of hearing, it has come to our knowledge that Lordship has also submitted in the affidavit that the license has to be obtained. So April 2023, they have filed the affidavit saying that the obtaining of license is under process. Now the state, the council for the state is saying that license has been obtained. So Lordship, in that case, they also mentioned during the, as the case progressed, Lordship, they have filed in the affidavit that 3 blood banks in the district of Cheongsang, Kifri and Mon are under construction. And Pek.
5. That's number 5.
2 to 4.
2 to 4, Lordship.
2 to 4. Well, Lordship, we have filed an affidavit stating that we have undertaken 4 blood bank, construction of blood bank in 4 districts, Lordship. Pingsang, Kifri, Mon, and Pek. Lordship, there's a procedure to be followed for setting up a blood bank, Lordship. Minimum of 2,000 unit has to be consumed in a particular blood bank, Lordship. If there's no consumption, Lordship, then we can only have a blood storage unit. Yes. Lordship, there are a lot of technicalities involved, Lordship. And to get a blood component separated, Lordship, there should be a registered blood bank. So we have explained, Lordship, in our affidavit.
What is the rule about blood component separator?
We should have a blood bank, registered blood bank in the particular unit. The first and foremost thing is, Lordship, there should be
First prayer was to set up blood banks in all district hospitals.
in all district hospitals. Lordship, that depends because we cannot choose, Lordship, because we have to show that there's a consumption. of at least 2,000 units in a year by the health unit. Now, unless we can show that like there's a consumption portion, we cannot get a blood bank license. And the blood bank license is given by the ministry. The state cannot on its own set up a blood bank license.
Settled on it.
Yes, Lordship, fortunately, we could get 4 in the district of Kifri, Tingsang, Muon, and Thak.
And in Kohima,
Kohima is already there. Dimapur, we have. So there's a procedure to be followed.
what is this blood? Which paragraph of the PI you have mentioned about this blood component separator? Let us have an idea also.
Lordship, starting with page number 34, Lordship.
24,
34, Lordship.
34.
Yes. Can you allow me to read? Blood transfusions are given to patients to provide them with a blood product to supply the part or parts of blood that they do not have. There are many types of blood products. The components that can be made from blood are red blood cells, platelets, plasma, and cryoprecipitate. Plasma may also be made into special products such as albumin, clotting factor concentrate on, and immune globulins. Each part of the blood has different functions. Separating the blood into parts lets patient get only the specific part or parts of the blood that they need. So a whole blood donation can be used for several patients. When a person needs blood as part of her treatment, the benefits should be greater than the risks. According to the report published by the Morung Express titled Patients Suffer as Blood Component Separator Lie Unused in NHAK, dated 17/02/2021, various doctors highlighted the importance of blood component separator and the risk of infusing whole blood to the patients who require a fraction of certain blood component. The relevant paragraphs are produced below. A doctor from Kohima narrating how he had to refer a young boy from a poor background suffering from leukemia to Gauhati due to non-availability of blood component separator. Said, the machine is an essential part of healthcare. Dealing with critical care, we really need a blood component separator. A blood component separator is a must-have machine. If we are to treat serious patients with cancer, renal failures, and other critical patients, the doctor said, explaining its importance, ideally when a patient comes with low hemoglobin, he or she needs only red blood cells rather than the whole blood. Similarly, when a patient comes with low platelet, he or she needs only platelet rather than the whole blood, and the same goes for bleeding disorders. Currently, the state practice in Kohima is treating everything with whole blood, irrespective of which components is required. However, he cautioned that such practice will cause UID and solute overload, which has its own complications. Due to non-availability of blood components in Kohima, we are denying sick patients the best possible treatment, and not only that, we are sending patients out of Kohima, especially leukemia and cancer patients, he stated. While it is an urgent requirement for the capital town, he also opined that it would be even better if one blood component separator could be installed in Mokokchu, so that it can cover parts of Longland, Zeniboto, and Twangsang district. Now, Lordship, the issue raised in this petition is that since, as we know, also placed in record, the statement given by the medical doctor themselves, the blood component separator is very essential. So that's why, since the machine was already there in Naga Hospital Authority, Kohima, then it was not made functional. So
it was brought what in the year 2016, 17?
yes, Lordship, yes, as per the record, Lordship. So it was not functional till this petition was filed. So, Lordship, accordingly, another prayer.
There was another one in Dimapur
Yes, Lordship.
that is functioning.
Yes, I'm told, Lordship, that is functioning. So, Lordship, the other prayer that we have was to have at least one more blood component separator in the eastern area, Lordship. So that the patient doesn't have to travel all the way from far-flung district like Mong Chuan Sang, Longdan, just to come to Kohima for this, Lordship.
Yes, now I can understand.
In fact, Lordship, there's a development, positive development as per the affidavit by the state respondents that.
Why?
So, Lordship,
Now the
That
bank
is
will be,
one by-
blood bank will be operational. Then after only the issue of blood component separator will come. Now, Lordship, we will run the blood bank. But if there is no consumption of 200 units, 2000 units in a year, then the license get cancelled by the government.
2,000 units. Why? There is no requirement for 2,000 units.
But Lordship, that is the criteria later on. I can place the criteria as Lordship. Because at its own whims and wishes, we cannot open up blood bank, Lordship. Because we have to fulfill the criteria of the government of India. The guideline that is given. to
Blood
us.
banks are operating in Dimapur and Kohima.
Kohima, Lordship.
And in any other place?
Lordship, it's under construction, Lordship.
Which places?
Uh,
Which other places?
Peren, Katuinsang, Kifri,
In which
Mo-
affidavit it is, in which affidavit it is reported?
Lordship, is in my
By respondent number?
page
Respondent number?
2 to 4.
4.
Yes, Lordship. Lordship, may kindly come to my affidavit.
Filed by Dr. Ritu.
Yeah, written to Lordship. Page 6, Lordship. And this has been funded by the NESIT. Northeast Special Infrastructural Development Scheme. Yes. Lordship, may kindly come to the table, Lordship. Serial number 1.
It was in 2020.
20.
COVID time.
Yes.
Setting up hospitals of Vientiane, Kifri, yeah, more than that.
So once the blood bank becomes operational, Lordship, then we'll have to apply for blood component separator.
Whether it was set up or not.
Lordship, as per the last information, Lordship, the work order has been issued.
It was sanctioned as far back as on 2020.
Yes, sanction was done, Lordship, but the issue of release of money, sanction is done. After that, only the money is released.
Money,
Work-
when it
work-
was released.
Yes, work order was issued on 19/10/2022 to 1 KM Enterprise. Annexure 2, page 10 Lordship, of my app. And we need a specialized firm to execute the work. Lordship. Lordship, may kindly come to page 12.
So
the
that was within 90 days.
Lordship.
Whether it is completed or not.
Lordship, that I can update the Lordship.
Installation.
Yes, Lordship. No, Lordship, may
Because
kindly come to page 12.
Supply should be made within 90 days from the date of issue of this order, failing which the supply shall be treated as cancelled.
Yes. Now, Lordship, may kindly come to page 12. The annexure. These are the particulars to be set up.
Whatever they are well aware, the supplier, the
Lordship,
contractor,
I can update you.
he is an expert in the field
Yes, Lordship.
of setting up blood banks. And his work order is for within a period of 90 days, he is to install.
Lordship, but
Whether it is installed or not,
the issue is for districts.
or
Lordship.
whatever,
So, Lordship, I can place
if he has accepted this work order,
Lordship.
meaning thereby he is required to install it within 90
I can
days.
update it. Lordship. I can update it in the next.
Get that information also.
Lordship.
What about this blood separator?
Blood component separator, as far as these districts are concerned, Lordship, only after it's functional, then we will have to apply for blood component separator. That is the procedure.
To get the information whether this has become operational or not.
Yes,
Yes,
Lordship.
Lordship.
I think
that is also my request. I was going to request that only, Lordship.
based on record, because
Now, again, another issue comes, Lordship. As far as the NHK is concerned, Kohima, we could not operate it because we don't have a technician having the requisite qualification, Lordship. So we have to send an employee who doesn't have a qualification, Lordship, for training
But
again.
for a timing,
From
the
Gauhati.
setting blood bank is the minimum requirement.
Yes, Lord.
If you have issued the work order, it should be installed
Yes.
and it should be up and running by this time. Get that information, at least 4 blood banks. This is, this blood bank, blood component separator. It is a high-end thing,
Patients.
requiring specialized
Persons.
and,
Yes.
special expertise.
Lord.
So for blood bank operation, I don't think.
That I can get information. Sometimes.
Yes, Ms. Pooja, this-
Lordship,
let
I have
us-
no
let
objection.
us-
Let him file the status,
Let
Lordship.
him place instruction as regards installation and operation of blood banks in the 4 districts.
Yes, Lordship.
And secondly, about you wanted to
Please on record the license that is regarding.
license
Yes.
as regards this blood component.
Yes, Lord. At NHE.
Anybody representing any other respondents? Mr. Hart, MS. Hart, Ms. Meet your project. Council for the petition. Petitioners. Mr. N. Mojui. Council for response number 2 to 4. Who represents 1?
What is the chief secretary? You take my affidavit over the still.
Okay, 2 to 4. Mr. Yangarpati, you represent 5 and 6. 5 and 6 as well. Union of India, Ministry of Health and Family Welfare. I don't know. This 5 is National Blood Transfusion Council.
It will be 5 and 6.
Yangarpati line, Central Council for Response of Finance. Course of deliberation, comma. It has come to the notice that the Ministry of Donor, comma, Government of India accorded administrative and financial sanction under the Northeast Special Infrastructure Development Scheme, in bracket NESIDS, on 2/7/2020, inter alia for setting up of blood banks at the district hospitals of Tuensang, Kifire, Mon, and Fake at for a total amount of rupees 167.80 lakhs at rupees 41.95 lakh per blood bank. In the affidavit in opposition filed on behalf of the respondent number 2 to 4, it has been stated that after a bidding process, comma, and work order for setting up of blood banks at the district hospitals of Tuensang, Kifire, Mon, and Fek has been issued to the contractor on 19/10/2022. 2022?
22.
Full stop. It is Mr. Mojui, Council Presently, the respondent number 2 to 4 has submitted that he has no instruction as to whether the blood banks, 4 blood banks, have been installed and have become operational in the meantime. Full stop. From the work order, it is noticed that the supply was to be made within 90 days from the date of issuance of the work order on 19 to 2022. Failing which the supply shall be treated as cancelled. The contractor was required to give demonstration before uh, in on the next date of listing, the Royal Council for the respondent 2 to 4 shall place instruction as to whether the 4 blood banks at order to be installed at the district hospitals of Tuensan, Kifire, Mon, and Fek have been installed or not, and as to whether these blood banks have become operational or not. Where Mr. Mojui has further submitted that the these are all technical terms. I have to see what exactly is the word. Blood component separator. For installation of blood component separator, a requisite license from the licensing authority is signed QAnon. Full stop. He has received instruction that the requisite license has since been received from the licensing authority, central licensing authority. Full stop. For installation of blood component separator, certain other prerequisites are required to be complied with. Full stop. He has submitted that if the matter is listed after 2 weeks, you'll be able to place up-to-date instructions as regards the installation of blood component separator, as agreed to by the Learned Council for the parties. Thanks. Please the matter on 10 or 17. What do you prefer, 10 or 17? 17. Release the matter on 17 for placement of instruction as regards the 4 blood banks at so and so, and the up-to-date status as regards blood component separation.
At NHK.
NHK.
At NHK Kohima.
At NHAK Kohima.
For admission, item number 4.
My lords, item 4 and 5, both are ready for hearing. Lordships, I was told that there are some time limitations today for the
This is CROP. What is CROP? Criminal?
criminal petition.
Okay. Yes.
I was told, my lord, that there are some time limitations for the hearing bench today. Because if we start, your lordship will take time.
It will take time. Yes, Mr. One partner matter of Mr. Zamir is there in the single bench for me.
Yes.
Put item, leave it to your lordships. Otherwise, put item 4 and 5
It would
Yes, sir.
take time.
Yes,
The
ma'am.
way it will take a short time, but I don't know, since he is the appellant in both the cases. Otherwise, so far as item 5 is concerned, Lord Chiefs. So far as item 5 is concerned, there is emergency, and the last occasion also I have pointed out that promotional avenues of all the officers in the department have been stopped in view of pendency of this case, because the officiating promotion is possible only once. Otherwise, unless it is regularized, they cannot be promoted. So in view of this problem, the matter is pending for quite a long time.
We can propose it the next week,
Otherwise, the
then
matter is simple.
we can propose it for the next week listing.
Next
My
week,
brother is.
Next week, my Lord Justice Kohima
you cannot take up this.
is sitting for 3 weeks and he cannot take up this matter, Lord.
My brother has some.
I understand, Lord.
Otherwise, I will bring him in.
That is a difficulty. Justice Sema.
Counsel for the respondent.
Next week. Let us examine first what is the issue. in gist, then we'll take a decision.
Yes, madam.
Then we'll take a decision. Mrs. Amir,
Which one? Which one, madam?
huh?
Which item?
Urgency
I don't know.
involvement is item 5, Lord.
These are related or
No,
separate?
no, separate.
Not
Okay, separate.
Separate.
So this item number 4 does not have any,
No urgency, Lord.
or is there, Justice Sema will have difficulty?
No, Lordship. there
For
no
4 is
difficulty.
concerned, no.
In both, he has difficulty in both.
But so far as item number 4 is concerned, there is no urgency, Lordship.
Okay.
I think 5 may
A.
explain, madam.
Jimomi,
Yes.
learned counsel for the petitioner, and Mrs. C.P. Jamil, senior counsel for the respondents. Justice Sema will not have any problem here. Item 4.
Item 4 also he has.
Yes.
Uh,
After 3 weeks.
After 3 weeks. As soft format. Release the case after 3 weeks. Now let us see item 5.
Can I briefly, my lord, may I inform your lordships about the facts? Or your lordships, in the year 1989, a decision was taken by the central government. A policy decision was taken by the central government to integrate all engineering services into one department known as the Department of Works and Housing.
Department of Works and Housing.
All engineering services. Now, at that relevant point of time, there were some posts, there were 2 posts of assistant architects. So these posts, 2 posts of assistant architects were integrated into the Department of Works and Housing.
They were
Into the
integrated.
Department of Works and Housing. Subsequently, in the year, one post of assistant architect was created exclusively for the Town and Country Planning Department after the amalgamation.
So Town and Country Planning Department was part of the amalgamation or outside it?
Outside. So after the amalgamation, for the Town and Country Planning Department, Town and Country, your worship, well aware, architects are required. One post of assistant architect was created for the Town and Country Planning Department. Now, for filling up that post, the Town and Country Planning Department sent a requisition to the NPSC. NPSC, relying on the amalgamation, issued instructions, wrote to the Town and Country Planning Department, saying that you have to route your requisition through the Works and Housing Department. That is where the mistake began. Otherwise, very clearly, your worships, amalgamation, 89, creation of the post, after the amalgamation, exclusively for the Department of Town and Country Planning.
Amalgamation did not include town and country planning department.
Your Lordship, it included at that point of time engineering services. But after the post, where the two posts of assistant architects were integrated into the Department of Works, a separate post was created after amalgamation, and that post was created for the town and country planning department. Separate post was created post amalgamation, and as I was saying, so this post was sought to be filled up by the Department of Town and Country Planning. A requisition was sent.
What is the post? Assistant
Architect.
architect.
So the NPSC, relying on the amalgamation of 1989, said that you have to route your requisition to the Department of Works. Because of that instruction from the NPSC, it was all vacancies, all subsequent vacancies in the post of assistant architect, they given to the Department of Works. That was the first mistake, Your Lordship. What happened in this case? Then, the appellant here, she was appointed to the NPSC as an assistant architect. And of course, the requisition was sent to the local.
This petitioner or what?
The
Appellant?
The appellant.
Appellant.
Yes. So,
She was
assistant architect,
when? After post amalgamation?
post amalgamation,
Post amalgamation in works and housing or town and country planning?
against the post created for the town and country planning.
That post.
Yes, against that post. So, one post of assistant architect, so she applied for that post and she was voted against that post, but again, through that mistaken process of routing the selection to the Department of Works and Housing. Now, there is only one post of assistant architect. There was no rules at that point of time in the Department of Town and Country Planning. There were no rules, only one post of assistant architect. And there were draft rules. The equivalent post is assistant town planner, who is also an architect, just a change of nomenclature. So the practice then was that those who are appointed as assistant architects, whenever the vacancy in the assistant town planner arose, because there was no promotional avenue for assistant architects, even in the draft service. The empty point was assistant town planner. Draft service was the designated one. So assistant architects, whenever the vacancy arose in the assistant town planner, that person was absorbed as an assistant town planner. That was the practice which was being followed. Now, one person assistant town planner became vacant. The appellant, as well as the private respondent, they applied for that post. The private respondent was selected, and he joined as assistant. So, as assistant town planner, by a twist of fate, he joined first. Subsequently, since there was no promotional avenue for the post of assistant, a policy decision was again taken that the post, the sole post, being a single post, assistant architect, would be redesignated as assistant town planner. And that post was included in the rules. The rules subsequently came to force. So the post of assistant architect, which the appellant was holding, was brought under the purview of the rules, specifically mentioned in the rules. Respondent by the writ petition challenging the rules and the inclusion of the post of assistant architect. In the course of the proceedings, the Lordship, the respondent, they withdrew the challenge to the rules. Withdrew the challenge to the rules. So, which means the redesignation of the post of assistant architect to assistant town planner is beyond challenge now. It's beyond challenge. The matter being thus situated, Your Lordship.
No, who are they? Who are they?
He is the respondent. He is the respondent.
I am the writ petitioner.
No,
Yes.
no, they are the writ petitioners or you are the writ petitioner?
Yeah, he's the.
I am the writ petitioner.
The private respondent is writ petitioner. Mr. C. General is representing the interveners. An
No,
association.
writ petitioner was
An assistant town planner.
Assistant town planner.
assistant town planner from the works and housing or?
No. From the urban development. I was appointed in 2004 as assistant town planner.
Urban development?
Yes.
This
No,
is-
Now it has been redesignated as
Redesignation
urban
was
development
done.
department.
It was earlier it was known as the town and country planning. Now it has been redesignated and renamed as a
You were assistant
town planner.
and you were assistant architect.
Assistant architect.
Which one is higher?
In terms of the rules of 91, Your Lordship, in terms of the rules of 91, assistant architect is higher. The draft rules,
As of now, Lordship,
but now equal,
equal, Lordship.
now equal. With the rules, with the adoption of the rules, assistant architect has merged with assistant town planner.
Okay, and why the intervener? Who is the intervener?
An association in the department
Lordship, here
Who are
the
objecting-
planning cadres.
who are objecting to my,
They
who are
are the
objecting
planning
to my
cadres.
inclusion in the department. And they haven't had to be, they have been had to be without any notice and that.
So why, Mr. Jami, you have urgency? You are intervener, they are fighting.
Lordship, it's like this. The division bench has allowed the respondent number 9 to intervene in the case, allowed to file affidavit in opposition where filed. How we are agreed, Lordship?
You are not entitled to any relief as an intervener.
We are affected by any order passed.
You can
in this-
either sail with the appellant or you can sail with the respondent. You don't have any right to relief as an intervener. If you are implemented simply as an intervener, that is the law.
Yes,
Because affected parties are the appellant and the likely to be affected are the private respondent. You are an intervener of association.
Lordship.
You can either sail with him or sail with him.
Yes,
You can supplement their submissions.
yes.
You are not entitled to any relief as an intervener. So I don't think you have any urgency in the case.
Lordship, what is the urgency for us is the promotional avenues of all the employees in the department are stopped. There are eligible persons who are working in the same force for the last 25 years. Because the present appellant, who was the respondent in the writ petition, the post held by her has been redesignated.
Is there any interim order operating?
No, no.
There is no interim order, Lordship. Now, what happened is, Lordship,
Just a minute. In the red petition, as originally filed by that, there was an interim order preventing me from being promoted. I filed an application, the interim order was created. And it was on who held that in the time, wishing promotion to be done. And that also after the challenge to the rules was being done.
Who is the intervener here?
how we are interested is, Lordship, the present appellant has been brought in by way of a redesignation that is contrary to the provisions of the service road. So the interest of the association is to protect the provisions of the service road. When the service road is framed, it has to be followed meticulously, and any action contrary to the rules that should not be allowed, Lordship.
You are
Because it will lay down a bad precedent,
Nagaland Physical Planners Association.
Lordship. And urban development is a department. with
You
the-
got implemented yourself in the
Yes.
appeal or in the writ petition?
In the red petition.
In the writ petition, Lordship. And initially it was placed before a division bench, since the provisions of the service road has been challenged. Now, the division bench has allowed us to intervene and to file affidavit in opposition. So we have done that.
Tell me, what is the role of an intervener and right of an intervener?
Role of the intervener is to intervene. Lordship, in the application, the division bench by order dated 25/2015 and perusal of the pleadings in the applications, I have been allowed to intervene in the case. So accordingly, the affidavit has been filed. And
Otherwise, what is the rights of an intervener?
rights of an intervener is to intervene in the case.
Not to get any relief.
No. But the outcome of the case
You
will,
can add weight. You can add weight
yes,
by 10 kgs, 100 kgs to the submissions of either
either way,
of the parties.
yes,
That is your role.
yes.
I think that is your rule.
Yes, Lord.
That is, at the last, you can either support this side or support that side.
Lord.
That is your rule.
Yes.
Who is the judgment otherwise? Impugn judgment.
It's a-
I don't think, Mr. Jimomi, it is a short matter.
It's not a problem.
It is not a short matter. Page?
After the cost, I think the sixth page. Oh, sixth page.
Page 50.
From the sixth page, from the beginning, from the first. From the beginning.
Oh. Dated.
8/4/22. 8/4/22.
8/4/2023.
Lordship, it will be in the beginning.
Huh?
Beginning, sixth page after, from the beginning, sixth.
Quite a lengthy different volume. 18 pages.
You were respondent number 8 there.
Yes, sir.
Who did the re-designation?
The government. The government.
Government.
Can I take your lordship just to make things very clear? There's a bundle compilation A. Compilation A.
This one.
Yes. No, there's a separate compilation. A, I have nominated this A. I find it separate. Compilation.
Not there. It is not by Justice Sema or Justice Sema or the council.
He was the counsel, in fact. He filed the case.
Okay.
Initially, he filed the case when he was a private.
Let us read the judgment so that we can understand.
Can I take your worship to your operative portion
No, so that we can understand the facts also.
from the beginning?
Ah,
Can we read that?
yes, please.
Mr. Owner,
You leave aside that. From paragraph 2.
from paragraph two. The present petition is filed by the petitioner, challenging the following. Notification dated 29/6, issued by the planning and coordination department, redesignating the post of assistant architect in the department of house assistant town planner in the planning and coordination department, creation of the post of assistant town planner, redesignating incorporated the schedule 2 of the Nagaland Town and Country Planning Service 2004 and the appointment of the respondent 8 in the redesignated. The office memorandum dated 26/10 issued by the Urban Development Department, publishing the final priority list of the gazetted officers as on 1/2010 in the Directorate of Urban Development. As the schedule of the service rules was under challenge, the matter was placed before and taken up by the division bench. However, the challenge to the service rule was withdrawn and a submission was made before the division bench that the petitioner will confine his challenge to the interstate minority between the petitioner and the respondent 8. The division bench finds order dated 26/10/16 directed the present petition to be placed before the single bench. Accordingly, this matter is the first. Or, the dispute not to be determined is the interstate minority between the petitioner and the respondent 8. The undisputed fact regarding the initial entry to the petitioner and the respondent 8 are number. On 17/1000, the respondent 8 of the due selection by the Nagaland Public Service Commission was appointed as assistant architect under the Nagaland Public Works Department and was posted as assistant architect in the office of the chief town planner Nagaland Kohima. Pursuant to a selection, the petitioner was appointed on 19/3/2004 to the post of assistant town planner under the establishment of the Urban Development Department, posted as assistant town planner.
So you were initially appointed as assistant architect
Yes, sir.
in 2000. Then thereafter, pursuant to a selection,
The petitioner was appointed as assistant town planner in 2004.
okay, 2004.
Thus, at the entry into service, the parent department of the respondent number 8 was Public Works Department, and it is worth mentioning that at the time of appointment of the petitioner and the respondent number 8, the town planning establishment was under planning and coordination department, but subsequently the same was brought under the development department. So this is the finding, even from the beginning, the finding of the single judge is that I am under the public works department. So what do you mean? This is
So
a finding.
this, according to you, this finding is
It's wrong.
wrong.
Yes. A mistake has been made law, and law has turned out to be a mistake. In
So,
short, that is my case.
so basically, your case is that the history of the events suggests otherwise.
Yes, ma'am.
So approach of the learned single judge
Wrong.
from the very beginning
It's wrong.
was wrong.
And not only that, madam, the learned single judge has come to the conclusion that I am bound by the engineering service rules, which is a different set of rules. Now, in the engineering service rules, the post of assistant architect is a 100% promotional post. It is not a post of director. They are also wrong.
And how this process has stalled the promotional avenues of the association members?
Unless we are promoted, the persons in the lower ranks cannot be promoted. That is the thing.
Lordship, by way of redesignation, the private respondent has been brought to the department as a cadre post. So she is holding a cadre post. Otherwise, her appointment was by the PWD. All along she was in the PWD. Her permission to go for further study was sought from the PWD department. Leave was granted by the PWD department. But in 2006, she was redesignated. So the post was redesignated, not the person concerned. Redesignation, upgradation, amalgamation, that is the bureaucratic of the government. Redesignation of the post was not engraved in the person concerned, only the post was redesignated. Any person may come and go. But as per the provisions of the service rule, redesignation is not there. One can be appointed, one can become a gatherer only by way of appointment or by absorption by in the deputation post or by promotion. Otherwise, there is no provision in the service rule for redesignation. If such practices are allowed, then any person may be deputed to the department and redesignate the post and they will be absorbed in the post. But redesignation, all right. But redesignation do not automatically become a gather officer in the department. Redesignation can be done. Any person may be absorbed in that particular post. Only the redesignation of the post will not confer a right to become a member of the gather. We are the gather officers. And if such practices are allowed, anytime any person may come from any department and occupy the post in the higher level, and we will not get the chance to get promoted to that post. So in other words, the appellant is occupying a post which is normally to be manned by the cadre officers. And this redesignation and making a member of the cadre by way of designating the post do not automatically become a member of the cadre. That is our grievance.
From the submissions, it appears it will require extensive hearing. It is not that easy thing. And from tomorrow, we have holidays, otherwise we could have extended it.
Part of the story has not been mentioned. First, I was saying, there was a mistake in the mission. After I joined service, as was the practice, I applied for study.
No, we have to go by documents. It means from the story projected by Mr. Jamir and Mr. Jimomi, it appears that we have to go by documents.
Yes, ma'am.
If you are saying that Radit single judge from the very first step was erroneous in his approach, and redesignation, merger, all these things have come.
Yes,
That
ma'am.
will be- Had it been tomorrow been open, I would have extended. But like yesterday's case,
When I went for study,
I don't think.
the was appointed in my place and by the town country as
Mr. Jamir, you have to be here for some more time. It appears. I don't think it is possible. Tomorrow is a holiday. Otherwise, this bench is splitting up. But Mr. Jamir and Mr. Edi Chaudhary both will be here. Mr. Justice Chema and Justice Edi Chaudhary. Both will be here.
Yes. And this is just.
Edi Chaudhary
As
is
per the present constitution of the bench's lordship, another 3 weeks. Placed up to 3 weeks.
Otherwise, no interim order is operating.
No.
State Council can be well advised to proceed. For the appellant. Mr. Apok Ponjina for the learned council for respondent number 1. Mr. MSP Supri for the state respondent, Mr. CP Jamil, assisted by Mr. I. Chen, learned council for the respondent number 9. Intervene. We take it upon ourselves due to paucity of time for hearing. Let the case be listed. Okay. This is your compilation.
Yes, my lord.
For hearing, item number.
MS Sukri, your seal packets, you have received.
For hearing, item number 6.
Oh, Mr. Jamir. That order I signed today, that all these.
Ex-servicemen.
Ah. Yes, Mr. Singh.
Please, your lordships. Your
Yes,
lordship, it appears today there are some other matters
yes,
also.
is there any bar against judgment rendered by whom?
Lordship,
Judgment, okay, this can be taken up by the next division bench also. You want to do it?
Yes, my lord.
lordship, if we have to argue and it takes time, then
Takes
do
time,
not, it may take some time, lordship, to point out.
My
all
lord,
the
just
facts.
15 minutes.
15 minutes. 15 minutes.
No, that is his submission.
And Mr. Seki, you need how much time?
Lordship, it may take shortest, it may take at least half an hour, my lord. To point out the,
Oh, stay is operating against you.
Yes, my lord.
What is the subject matter otherwise?
no, your lordship, basically, the point of law before the Honorable Court on Appeal is that I filed a preliminary objection and the learned single bench, after hearing the preliminary objection, whether it is rejected or allowed, the writ petition should have been allowed to be continued, your lordship. But without allowing the respondent, that is my client, the appellant, to file the affidavit in opposition, the matter was disposed of in the preliminary objection itself, your lordship. That is the first point.
Okay, you raised the preliminary objection on what issue?
On the maintainability of the
On the
petition.
maintenance of the writ petition.
Yes,
Okay, on what is the ground that the writ petition was not maintainable?
that he was overaged. The petitioner was overaged in approaching the, while approaching the Honorable Court. So in the first place, when
Overage.
the,
So
yes,
what was the relief he sought for in the writ petition?
the relief sought by the petitioner is that my appointment should go, my client's appointment should go, and then he should be the one to be appointed. But did he,
Okay, you were appointed.
yes, I was appointed.
You were appointed
Against a grade 4 post.
grade 4 post on landowner or compassionate or direct contractual?
No, lordship, it's a direct appointment, lordship.
Direct appointment
Yes, ma'am.
by regular selection process,
There was an interview, your lordship.
interview,
Yes, lordship.
grade 4.
Yes, madam.
Okay.
So I was selected, then the petitioner came to this Honorable Court claiming that they are landowners. Oh, my lord, as far as the land ownership is concerned, I have no dispute with that. But the issue is that he was overaged. So when a person is already overaged for entering into public service, then a question of locus comes while approaching the Honorable Court. A person who is not eligible for appointment has no locus in the first place to approach the Honorable Court.
He filed a writ petition.
Yes, madam.
Saying that he is entitled for the post on the ground
Basis
of,
of land
on the
ownership.
basis of land ownership,
Yes, lord.
right?
Yes, madam.
And in that post, you were already appointed.
Yes, lordship. Then, my
You were
lord-
already appointed.
Yes, lordship. After the first preliminary argument had taken place before
Okay.
the learned single bench,
Ah,
my lord, did the present appellant went looking for documents and found out that even in the school record, the certified copy of the school record, it was found that he had tampered with his age to enter into public service, which can also be a criminal offense, your lordship, for tampering with official documents. So, lordship,
did the last single judge deliberated on the issue?
your lordship, not on the additional document which I have placed in the appeal memo, your lordship. I have taken the shelter of Order 41, Rule 27 to place the additional documents which were not allowed to be placed before a learned single bench because the matter was disposed of after hearing the preliminary objection, Your Lordship.
No, is it reflected there on that?
Yes, there also, even in the official document that he placed before the Honorable Court. Yes, Lordship.
Is it reflected that after hearing on the preliminary issue,
Yes,
the repetition has been disposed of?
yes, Your Lordship.
Where is that?
Your Lordship, the judgment and order is at page 71, annexure F, page 71.
Yes.
May I read, Your Lordships, starting from page 72.
Now, where is it that you have raised preliminary issue on the maintainability? And
yes, Your
that was rejected.
My lord, my lord.
And the court proceeded whether it can be discernible. You have raised it verbally or what?
My lord?
The preliminary issue has been raised verbally
No, Lordship.
by filing short affidavit.
Yes, Lordship.
By filing short affidavit.
Yeah, only on the preliminary ground, Your Lordship.
No.
Yes,
I
Lordship.
have asked you
My lord.
that whether you have raised this preliminary issue orally or by filing a preliminary affidavit in opposition.
Page 47, Your Lordship. My lord, may kindly come to the court side.
I am asking you, you have said.
I have filed, Your Lordship.
You have filed an affidavit.
Yes, preliminary objection. Page 47, annexure B. 47, my lord. This is my affidavit, my lords. Preliminary objection affidavit for and on behalf of respondent number 5 in the above mentioned writ petition. So all that was raised in the affidavit is a preliminary objection. Affidavit in opposition was yet to be filed, my lords.
State respondents had filed affidavit.
They had filed their affidavit, Your Lordship. But the argument was purely on the maintainability and whether there was delay in approaching the zoning board for the learned civil bench. And at this appeal stage, if my lords may allow the Order 41 Rule 27 to place some additional documents for the perusal of this Honorable Division Bench, then my lords will see that he was actually, the record placed before a learned civil bench was also overaged. But in his actual age from the school record, the original school record, he is again much older than the manufactured birth certificate that he produced before a learned civil bench.
Are you a descendant of Pujon? Are you a descendant of Pujon?
Your Lordship, as far as my appointment is concerned, some of them, not on the basis of land ownership.
Otherwise, no regular process.
Your Lordship,
There was no regular process of appointment. And it is completely violation of Article 14 and 16. If you are not basis of land ownership,
my lord.
if your appointment was not on the basis of land ownership, then it would be in clear violation of Article 14 and Article 16, which cannot be sustained otherwise. But if your appointment, if you claim on the basis of which the petitioner has contended, that on the basis of land ownership, then we can modify this order direction as well as a single judge to the extent that both the cases of the petitioner as well as the respondent number 5 shall be considered on the basis of land ownership, on the basis of supporting documents. If you are not a descendant of Pujon and Tepusio Tase, then you will be considered along with him. And if both,
Your Lordship.
otherwise
Yes,
your
Your
appointment is, we will not like to interfere.
Your Lordship.
14 and 16 violation.
Yes, Lordship. To that extent, I cannot disagree with your Lordships. So exercising the.
So we can only modify the direction of the single judge to the extent that for the purpose of filling up the post, vacant post, due to retirement of Tepusio Tase,
My lord.
cases of the petitioner, writ petitioner, as well as the respondent number 5 can be considered on the basis of supporting documents, and whoever has better claims, he should get. We can modify to that extent, subject to.
Or my lord,
Otherwise,
if I may be allowed.
when
my lord.
apparent violation
Yes.
of Article 14 and 16,
Lordship, as far as Article 14 and 16 is concerned, the extraordinary jurisdiction of the court, that the discretion, I do not question, my lord. But the second issue which I beg your lordships to kindly appreciate is when the person is overaged and cannot be considered for public employment, your lordship, and has approached the honorable court, when he has no locus standi in the first place to approach the honorable court, whether any relief can be granted to a person who cannot be considered a person with locus standi to approach the.
where are the notifications relaxing the age?
So as far as the relaxation is concerned, lordship, I'm not questioning that. Then may I take a lordship to kindly, my lords.
No, when did he first apply for the job?
In the year
After
2021.
21. That
Yes,
was
my lord.
discussed.
No, your lordship. That part is discussed. That part is discussed, my lord. But here, even assuming that I'm not disputing that, he has claimed that he was born in 1985 in that document which was placed before his own court. Now, if my lords may kindly come to Annexure J, allow me to kindly point out these to your lordships, starting from page 86.
Then
my lord.
Mr. Seki, that will go into a disputed territory. Page
Page 86, my lord. And your lordship,
86.
the relevant portion is page 88.
No, but how we have filed? Have you brought this order 41 rule 27?
Yes, lordship.
Did you file any additional application?
As far as the learned single bench is concerned, I didn't get the opportunity to file, my lord, because on preliminary ground, when the objection was heard, the order was kept CAV and then the matter was found to be disposed of when it was yet to be argued on merit, my lord, purely on technical ground. So the matter may kindly be referred.
Review.
My lord,
You should have filed review then.
lordship, the matter may kindly be reverted back to the learned single bench.
You
so
should have
that-
filed a review then. Because there are two things. Review is for the same bench. And appeal is continuation of the proceeding. Now, order 41, rule 27, it has to be filed separately. And whether this to allow or not to allow, it is at the time of final hearing. That is the law.
Your Lordship.
Otherwise, we have to decide on the basis of the materials on record.
Oh, my lord.
Unless
Yes, Your Lordship.
you get us satisfied.
Then, my lord, since the judgment in order of the learned single bench went beyond the pleadings to decide on the merit of the case when the objection was raised purely on the
You should have.
maintainability issue.
Because you have in the preliminary objection,
Your Lordship.
because you have said that
Hello.
we'll file additional affidavit in opposition if the necessity arises. Right, in your affidavit, preliminary affidavit,
Preliminary objection.
page, I think,
Yes.
page.
Page relevant portion, page 50, Your Lordship, the relevant paragraph 4. So, my lord, should the preliminary objection be rejected, then I was ready to file the affidavit in opposition, my lord. But I was also of the impression that the matter would not survive at the preliminary objection stage. So only if the preliminary objection fails, then on the merit, Your Lordship, the affidavit in opposition was to be filed.
Mr. Siki, we don't know what transpired. Deliberation took place before the land civil judge. But since it was your preliminary affidavit opposition, raising a ground issue of maintainability,
My lord.
and with the observation that with the statement made, where is your affidavit? Statement, paragraph
4.
4. You should have brought it by way of review, I think. Mr. Siki,
My lord.
we have the tentative view that we should prepare a review. Because this reservation you have made in paragraph 4,
My lord.
and what transpired we do not know. And after review, option they would definitely be open for you to
Naturally,
prepare an appeal
yes.
again.
If not, my lord. Naturally, my lords, given your vast experience in litigation, would appreciate that if the preliminary objection itself succeeded, that there was no necessity to file the affidavit in opposition. But assuming that if it does not succeed, then I was ready to file the affidavit in opposition. The language, in my humble understanding, Your Lordship. So it's simple.
Because if we, on the
expecting the
basis of
preliminary
this,
objection to
see whether there was forgery or not, all those things on order 41/27, order 41 rule 27 CPC. These are applications which are to be decided at the time of final hearing, whether we should admit it or not. And even if we admit, that goes into the disputed question. That requires a determination by in a full-fledged trial, whether he had done forgery or not.
Oh,
But
Lordship,
question from your side is to maintain your appointment
Your Lordship.
otherwise. But on the ground of 14, 16, we find that this is something which is not to be, when we take note of the fact how your appointments have been made. So only ground appears to be regional ground to contest your case vis-a-vis petitioner's case is to before the appointing authority. Because if you are not a descendant of those two, then your claim, otherwise you have no valid ground to continue with your appointment under Rule 16. Anyway, it has to go. We cannot shut our eyes off at the same time. At the
Well,
same time.
then, my lord, if my lords would like to exercise the authority under Article 14 and 16, then the matter may be reverted back to the authorities to examine, as my lord has already expressed.
This
your
I
lordship's
can do
opinion.
because his
I'm
case will be
open to that, your
considered.
lordships.
His case will be considered. But respondent of 5 writ appellant,
Yes.
he should also be granted the opportunity to vie for the same post.
Your lordship.
My lord.
That
regarding-
cancellation of his appointment by the learned single judge would not stand in the way for making a claim for appointment under the land ownership. Yes, please.
My lord, let me clarify whether he was appointed in the non-citizen. The affidavit filed by the state is very clear at page 58, my lord. Of the agreement, page 58. Paragraph 5. Paragraph 5. This is the affidavit of the appointing authority. Now read, my lord. The statement made in paragraph 4 of the writ petition is to extend one of the offense among others. It is respectfully stated that after the establishment of veterinary dispensary in Takana village, 5 landowners were appointed, including the respondent number 5. my lord. And the respondent number 5 is the
Okay, let them consider.
yes.
Let
So
them,
he was appointed on the basis of land ownership. And now his very appointment is not in consonance with the OM dated 16/8/2018. It is against the policy of the state government, his very appointment. Therefore, my lord may kindly appreciate the far cited wisdom of the learned single judge, whether he is allowed to file his affidavit in opposition or not. The only conclusion that can be drawn is that his very appointment is not in consonance with the OM dated 16/08/2018. Allow him to file his affidavit in opposition will be a futile exercise, and the theory of useless formality will be applicable in this case. Whether he is allowed to file or not, the only conclusion that can be drawn is that his very appointment is against the policy of the state government, and is not in consonance with the
no,
OM
now
dated
tell
16
me, just 1 minute. Tell me from the single judge judgment, is anything,
Oh, my lords,
any state respondents?
I need to apologize to your lordships. My lords, I made one inadvertent error in my submission. In fact, both of them are landowners. My sincere apologies, your lordships.
But whether state respondents had, Mr. Counsel, whether state in their affidavit in opposition had clearly stated that this respondent 5 was descendant of Fujon or Tepusio Tase.
My lord, that's not been stated, but my lord,
Is there any statement from the state side
but my lord,
that this respondent 5? No, I'm asking you a query, please. Yes or no? It should be yes or no. Whether state has specifically mentioned that respondent 5 is a descendant of Fujon
Yes, lordship.
or
Resolved.
Tepusio Tase.
no, my lord. Specifically, it has not been mentioned.
No.
No, no, my lord. That is clear. But however, my lord, in the Clean objection raised.
Here, because I am asking you, because paragraph 12 of the judgment, last line. This court also finds that the respondents have not refuted the claim that the respondent number 5 and Sri Tepusuo Tase are both descendants of the same landowner, Sri Kujong. Just because they have not refuted the claim does not automatically mean that they are the descendants of Kujong. Your father is Tepusuo? No. The person who retired?
It's not my father, Your Lordship,
Not father.
but we are descendants of Kuzum.
They are descendants of
Kujong.
Kuzum.
And are you, is there anything somewhere that you are descendant of Kujon or Tepusuo Tase?
In my
Tell
preliminary
me,
objection,
you have gone to
I
the,
was yet to go into the merit, only on the maintainability. So none of those are mentioned in my preliminary objection, Your Lordship.
state affidavit. Both of you compete. Both of you compete by submitting your application. You abstain. Did you say that he was, because he was made, he was given appointment on the basis of land ownership without following the regular selection procedure, right? Now, whether he was appointed as a descendant of Tepusuo Toja or Kujon,
Land ownership is a special, covered by a special notification issued by the KPI. Every owner can. So it is not sort of like.
where is the state affidavit? Where is the state affidavit? Let us see. 57.
Yes.
When the petitioner made application, dated 0907 C, the group petition, for according to the course of animal how whether the requirement not to the petitioner was yes, the petitioner. That's the only reason, Your Lordship. Otherwise.
Now,
we would have.
now Lawrence Single Judge has delivered a judgment.
Otherwise. So it's total. What are landowners? There's was qualified, we could have called for a selection process. Between the
Because-
landowners.
Because at that time,
Then
now,
the two landowners. But
now
now,
single judge, and a single judge has decided on the issue of age. Right? That his application filed in the year 2021 is covered by the Office of Memorandums, relaxation period. Right? That is one. Apparently, respondent 5 appointment was without following any selection process. It was on the basis of land ownership. Right. Now, Learned Signatures at the same time has also observed that his application ought to have been considered because he comes within the age relaxation period. That is what the Learned Signatures is saying.
As per the document under.
As per the document, as held categorically.
Lordship.
Now, both respondent 5 and the petitioner were claiming appointment on the basis of land ownership. Now, it is also the policy that once a descendant is appointed, once a predecessor is appointed, then from the same branch, nobody else can be appointed later on. So Thujon or the person who retired, their descendants cannot be appointed. If Mr. Seki's client turns out to be descendant of either of these two, his land ownership goes otherwise. Claim on land ownership basis. And this petitioner remains. So the state can consider both their applications on its own merits in terms of the office memorandum.
I'll follow the direction of this other.
No, I think that is the only way.
Otherwise, I'm willing to carry out any other perspective on that. Performer respondent.
Said it that the performer respondent only.
Yes, Mr. Seki. That will not preclude your cancellation of appointment by the land single judge will not preclude to take claim for appointment on the basis of land ownership vis-a-vis the claim of the application. But that should be strictly in terms of the office memorandum of the government of Nagaland. Otherwise, on primacy, appeal is on 2 points. Your appointment is otherwise found to be in violation of Article 16. It should go. But on the second issue, the single judge has considered that his application on the ground of overage was not acceptable. It was within time because of the policy of the government, COVID time office memorandum. I think both of you should compete.
Yes, ma'am.
Third, Mr. J. Shaki.
We're also leaving tomorrow.
My brother will be leaving today. That is the difficulty. Please take your seats. This intra-court appeal is directed against a judgment and order dated 6/10/2023 passed in a writ petition, WBC number 77/2023. Para. The writ appellant hearing was the respondent number 5 in the writ petition, WPC number 77/2022. Full stop. By the judgment and order dated 16/2023, comma, the appointment made in favor of the writ appellant as respond number 5 in a grade 4 post at veterinary dispensary, comma, Jakhama, has been set aside full stop. And quast, set aside and quast. Full stop. The petitioner therein, that is the respondent number 1, herein instituted the writ petition on the premise that the appointment of the writ appellant as respondent number 5 was made on the land ownership basis, was made on land ownership basis, but his application for appointment to the same post on land ownership basis was not considered. Full stop. In the writ petition, comma, the writ appellant as respondent number 5 raised a preliminary objection to the effect that at the time of preferring the application for the post in question, on what was the date of your application? Nine seven 2021. Comma, the petitioner, that's respondent number 1, was already overaged as he was over 30 where is your preliminary affidavit? Page?
Preliminary objection.
Affidavit.
Your Lordship, it's at page 47.
Over 35 years, comma, which is ordinarily the upper age limit for entry into government service. Full stop. Negating such contention raised as a preliminary issue on behalf of the writ appellant as respondent number 5, the learned single judge in view of two office memoranda, there's one dated 16/7/2021, providing for 1 year relaxation WEF 2204/2022, and the other dated 22/02/2022, providing relaxation for additional 2 years WEF 2204/2021, had
My lord, it would be 28/02/2022. The second OM.
second one.
Yes, my lord.
Okay, 28.
28/02/2022.
Okay. Providing for a 2 year, additional 2 years relaxation. Had observed that the application submitted by the petitioner, that's response number 1, or had to be considered, ought to have been considered as due to relaxation of age, upper age. Full stop. Para. Nalag, sir. Continue. With such observation, the writ petition was allowed, directing the state respondents to consider the application of the petitioner dated 9/7/2021 and to take immediate necessary steps for his appointment to a grade 4 post at veterinary dispensary, Zakhama, and pursuant to an agreement dated, by taking into consideration the agreement dated 8/12/1975 made by the landowners of Zakhama by the state authorities. Para. The post in grade 4 at veterinary dispensary Zakhama has arisen due to retirement of one Tepu Sio Tase, full stop. From the affidavit in opposition of the state respondents filing the writ petition, it has emerged that the writ appellant as respondent number 5 was appointed on the basis of land ownership, but without any kind of selection process in conformity with Article 14 and Article 16 of the Constitution of India. Full stop. From the case papers, it has further emerged that there was an agreement executed on 8/12/1975 made with the landowners of Jakhama by the state respondents to set up the veterinary dispensary at Jakhama. And as per the said agreement, the original landowner was one Pujon. Pujon? Khuzon. Pujon. Who donated the land, who donated his land for the purpose of establishing the veterinary dispensary at Jakham. Also. It has further emerged that Sri Tepusio Tase whose retirement has created the vacancy in grade 4. For which the writ appellant does respond number 5 and the petitioner does respond number 1 are competing. Was also appointed on the basis of as descendants of the original landowner, Pujon.
My lord, I am the descendant of Kosa, Kuosa.
Huh?
I am the descendant of Kosa, who is also a landowner.
So one of the okay. The agreement is here.
Yes, my lord.
Agreement is here somewhere.
Yes, my lord. At page number 20.
Page
The
number
type copy is at page number 20.
20.
20 of the-
No.
The type copy.
20.
Yes, the agreement is at 19, the type copy is at page number 20.
19.
Page 38, my lord.
38.
Oh, page 38. Yes.
Okay, so many. So a Khuzon to one of the landowners. In the case papers, the agreement dated 8/12/1975. Which one is correct? 14/12 or 1974? The agreement on the basis of which the land was taken over for establishment of the establishment of the veterinary dispensary is found available. And it reflects the name of (11) persons as landowners. Full stop, right?
Yes, my lord.
11 persons.
12, my lord.
Now he is village council chairman.
Yes, my lord.
Oh, my lord.
I have seen it.
My lord.
Uh, the if the appointment of the writ appellant, that's response number 5, was made on the basis of where is that memorandum and ownership office memorandum
16/08/2018.
page
Page number
44, my lord.
44, my lord.
is on the basis of land ownership, comma, the respondent authorities ought to have considered the cases of all applicants who have staked claim for appointment on that basis in terms of the office memorandum dated 16/8/2018. Full stop. From the in the affidavit in opposition filed by the state respondents in the writ petition, comma, the state government was found to have taken a stand that the respondent number writ appellant, stroke respondent number 5, was appointed on land ownership basis. Full stop. It had the state respondents had also taken a stand that till date, comma, 5 landowners were appointed. Paragraph 5. As the appointment as the admittedly, comma, the appointment of the writ appellant, yes, respondent number 5, to the post in grade 4 in veterinary dispensary Takama was made without any kind of selection process undertaken in conformity with the procedure laid down, conformity with the principles laid down in Article 14 and Article 16 of the Constitution of India. Full stop. But his appointment was shown to have been made on the basis of land ownership. Full stop. At the same time, comma, the petitioner has also staked his claim for appointment to the same post on a land ownership basis. Full stop. The matter of appointment on land ownership basis is governed and regulated by the policy framed by the government of Nagaland in by the office memorandum dated page 44,
44, 16/8/2016.
16/8/2018. Wherein it is laid down that it is not the policy of the government. Full stop. It is where is not full stop. The relevant clauses of the office memorandum dated 16/8/2018 reaches under clause 3, I think.
Yes, madam. 3B.
Clause 3B, page 44. 3 A, B দুইটা লিখে। As the learned single just while allowing the repetition, I had observed as under paragraph 14. Having considered the matter, having heard the learned counsel for the parties, and after considering the matter in its entirety, we have the considered view that the matter of filling up the post in grade 4 at veterinary dispensary Jakama shall be considered strictly in terms of the office memorandum dated 16/8/2018 by the state respondents, by the competent authority, in the state government. Full stop. We are of the further, we are also of the view that while considering the matter of we are not inclined to interfere with the order of cancellation of the appointment of the writ appellant as respondent number 5 by the single judge, in view of the fact that the appointment was otherwise not in conformity with the principles laid down in Article 14 and 16 of the Constitution of India. Full stop. As the direction has been made to fill up the vacancy in grade 4, resultant vacancy in grade 4 at the veterinary dispensary Jakama, strictly in terms of the office memorandum dated 16/8/2018, the cancellation of the appointment of the writ appellant as respondent number 5 by the learned single judge shall not operate as a bar for him to stake claim for appointment on the basis of land ownership vis-a-vis the petitioner does respond number 1 and any other applicants taking claim for appointment to the said post on the basis of land ownership. The direction made by the learned single judge stands modified to that extent.
That means state has to give an advertisement.
Full stop. Full stop. The state respondents while proceeding to fill up the vacancy in grade 4 at veterinary dispensary, Jakama shall invite applications from the eligible applicants claiming appointment on land ownership basis by virtue of the agreement dated আসলে না?
8/12/1975.
11 families.
That means those who have signed the agreement. Those who have
Huh.
signed the descendants of those who have signed the agreement. That means
I have already observed this state you have given 5, you have given already. 5 given, 11 out of 11, 5 given, 6 were there. So tomorrow another one will come again, will say that with wide publicity, and thereafter proceed to complete the entire exercise as expeditiously as possible, preferably within a period of 4 months from today. State is in best position to whom you have given appointment earlier, whom you have not given. You decide. Both of them compete.
Yes, ma'am.
And it is needless to say that the cases of the applicants are to be considered on the basis of authentic supporting documents. Authentic supporting documents.
Oblige, Your Lordships.
The writ appeal is disposed of in the apostate manner.
Oblige, Your Lordships.
দিদি কত মজরে এসডি লব
স্যার আমি ঠিক আছে
What was that? Okay, madam. 5 minutes. Hmm, 5 minutes. Kung nasa itu, apa yang jadi calon ada? Sir, apa yang jadi calon ada? Number one. In 5 minutes. In 5 minutes. This one, normally, just any moment judge will come out and then this is item number one. That's why judge will come out any moment and here that is item number one. So as soon as then I have to bring it, that will be difficult. No problem. But otherwise, any moment. चलो कोई इशू नहीं No more break. I mean, our farewell program now the Kushi, etc. The other one also chamber date is set. Hearing item is not likely.
No, who do you
Yeah, Kushi. And the other one is most likely to be dictated in this chamber.
Item number two.
Some queries may be there. Or maybe some queries.
Item two item one the motion.
You consider logo our farewell to push it.
Kali wrestling do buja rasa je.
Huh?
Wrestling do rasa je.
Check rain or shine, I didn't leave my seat. 500 rupees large ticket we here. Aste, upgrade, donors laga power body na petrol laga sikte jagi. Amuja lagi je. Very competitive, na. If it is one-sided, then no fun, na. Very competitive, na. That was the beauty of it. Definitely. Wrestling only always tricky. The biggest festival, even 20,000, 30,000 gather opportunity could have.
To enable me to watch the wrestling meet in Abu
Huh? On account of the wrestling festival. On account of the biggest festival in my books. Finally grant me casually for one day. Actually, liquidity meaning है ना, it was all biometric system ना. If you don't marry, then you are upset. Well, live liquidity meaningless. Approved or not approved, if you are feeling
As this court on earlier occasion also directed us, my lord, in 12 February, my lord, that this order is there, my lord. So accordingly, we filed.
12 February.
Yes, my lord. In their writ petition, madam, main writ petition.
If the council is available, we can pass order. Mr. Yangarvati, you represent the Director General of Assam Rifles.
Yes, my lord.
The application has been submitted seeking leave to serve notices upon the private respondents, respondent number 10 to 22, in a connected writ petition to the respondent number 2. What do you say? You were appointed or what?
My lord, my appointment.
No, 10 to 22
Yes, they
are
were-
serving
Yes.
serving
Yes, my
under
lord.
Assam Rifles.
Yes, correct, my lord.
Yes, you're the officer.
Okay, we'll try, Lordship.
They are working under you,
Yes,
so it can be served.
but I should be given sufficient time because they are posted everywhere. Yeah.
Okay.
No problem, my lord.
Okay.
No problem.
Heard Mr. N.K. Moody, Learned Counsel for the applicants. Writ petition, applicant writ petition. And Mr. Yangarvati, Learned Central Government Council, representing your respondent number 1 to 9. 1 to 9.
Yes, Lordship.
The applicant as a writ petitioner, has preferred the connected writ petition WBC number 236/2019. So these were implemented by any interlocutory application?
Yes, my lord. And there is an application 66/23, my lord.
The applicant number 10, oh sorry, the party respondent number 10 to 22, 10 TO 22. In the connected writ petition, have been implemented provide order dated 19/6/2023, passed in an interlocutory application, IA Civil 66/2023. Full stop. Para, the instant interlocutory application is preferred following leave granted by an order dated 12/2/2024, passed in WPC number 236/2019, whereby the writ petitioner, applicant writ petitioner, has been granted liberty to file an application seeking permission of the court to take steps for service of notice to the respondent number 10 to 22 through the respondent number 2. Post. Para, it has been averred that the respondent number 2 to 22, 10 to 22, in a connected writ petition WPC number 236/2019, are employees under the respondent number 2, that is the Director General of Assam Rifles. The applicant writ petitioner has sought leave to allow him to serve notices upon the respondent number 10 to 22 in the connected repetition WBC number 236/2019 to the respondent number 2. Mr. Yangarwati, learned Central Government Council, depending for the respondent number 1, 2, 9, including the respondent number 2, has submitted that admittedly, the respondent number 10 to 22 are employees of Assam Rifles, but they are posted at various places throughout the Northeast region. And as such, it would require some time for the respondent number 2 to serve notices upon them. In such view of the matter, Mr. Yangarwati has submitted that a period of
4 weeks.
6 weeks.
But first,
6 weeks.
6 weeks. Yes.
Be granted to the respondent number 2 to serve such notices to the respondent number 10 to 20.
I'm obliged.
just extra copies.
I
In view
will-
of
In course of the day,
in
my
view
lord, I
of
will serve.
such submissions made by the learned council for the parties, this the instant interlocutory application is allowed. The learned council for the petition, applicant petition, shall furnish requisite number of copies of the writ petition along with annexes to Mr. Yangarwati, learned CGC, within 3 working days from today. On receipt of such copies of the writ petition, the respondent number 2 shall take necessary steps for service of notice upon the respondent number 10 to 22 within a period of 6 weeks therefrom, and shall submit a compliance report to that effect within a period of 6 weeks there. You shift that to just yes, today is 7. This is Wednesday. List in the main repetition. Mr. N.K. Muri, learned council for the writ petitioner, and Mr. Yangarwati, learned Central Government Council for the respondent number 1 to 9. In view of the order passed today in IAC number 34/2024, list the case in the 3rd week of May. 3rd week of May, on a date to be fixed by the office.
Obliged, my lord. I am obliged, my lord.
For hearing item number 2.
Mr. Imchen, will pass the order, right? We have dictated hardly last few paragraphs remain because there is a meeting at the Employees Association.
Yes, Honorable.
Everybody would attend,
Yes, Honorable.
right?
Yes.
So, what I propose is that the proposal of the board regarding that absorption of 10 senior overaged medical officer IUs should be brought to a logical conclusion by the competent authority in the state government Health and Welfare Department, Health and Family Welfare Department. So far as the remaining 11 number of posts are concerned, the state government will be at liberty to proceed with the with uh, uh, with a process for filling up the post in the manner and prescribed by law. And the matter of filling up of these 10 posts will abide by the decision taken on the proposal of the board. If it is, suppose it is decided that it will be filled up by absorption of the contractual appointment, then it will not be advertised.
Yes, Your Lordship.
But if say they negative, then they will go for advertisement. In that case, they will challenge again.
Yes, Your Lordship. That is the only
Right?
possible way at this point. Yes.
Then you will have the option of challenging again
Yes,
that
Your Lordship.
decision,
Yes.
right?
Yes.
So we'll close it by
Yes.
that time.
At this juncture, that would be the best solution.
Dispose of. Dispose of. Okay.
Much obliged, Your Lordship.
Mr. Morin, you wanted to. Just a second. Okay, Your empty movie. No. Item number 2. Yesterday, registration method.
Only one test.